SwayamPrabha. Digital India. Educated India.
Welcome back to the course of Law of Torts, Consumer Protection and Motor Vehicles. Today in the fifth lecture, we will discuss a very important aspect of Law of Torts, which is liability. Now, as I mentioned in my earlier 4 lectures, the evolution of Law of Torts and what are the constituents of Law of Torts, then moving to what are the defenses that are available to justify and who has the capacity. Now, we are going to discuss about the liability today. Now, what is meant by the word liability? Now, liability means like once somebody has been accused of committing a wrongful act against someone who has suffered some injury of his legal right. Therefore, if it is proved, then that person incurs a liability which is a nature of tort liability. So, tort, if proved, incurs in the form of a liability of tort. So, that is liability. Now, in torts, liability may vary. There are various types of liabilities. Now, this chapter we will discuss, or this lecture we will discuss about the two types of liabilities which are commonly there used in torts. One is fault liability and one is no fault liability. So, the purpose of this lecture is to discuss about the fault and the no fault liability. In the next lecture, we will discuss about another very interesting type of liability, which is subordinate or secondary liability, which is called the vicarious liability. Now, the topics that will be covered in this chapter are following, in this lecture are following. First, we will discuss about the types of tortious liabilities. Followed by that, we will introduce to the concept of fault based liability. So, what is fault based liability? Then we will move to the next type of liability, which is the no fault liability, and where from this no fault liability has emerged in the law of torts, and it is also today in law of torts domain known as strict liability. So, what is this strict liability and how it works? And then we will discuss one important case in the strict liability which has modified the approach of strict liability and how it has modified, and what is the effect of this strict liability regime post this judgment. So, we will start our discussion with types of liabilities. So, what are the various types of liabilities that exist in the law of torts? Now, in our earlier discussion, we saw that when it comes to incurring responsibility in torts, there are 3 important components which are the constituents or elements to make tort a liability. The first is that there has to be a wrongful act on the part of the defendant. The second is that the wrongful act should kind of affect some legal right of the defendant, of the plaintiff. Now, at this juncture, we discussed 2 important maxims, injuria sine damno and damno sine injuria. Now, I just for the purpose of recap telling this, injuria sine damno means that where there is an injury has happened to the legal right, but no damage may or may not have incurred. So, the example that we discussed was the voting right, where the person who was having a rightful authority to cast his vote in the election was not allowed to cast his vote. That led to a filing of a suit saying that this is a violation of law in law of torts, and the court found that it was a violation of the injury to the person's legal right to vote. However, the defendant took the defense that anyway, even if injury has been sustained and we accept that and it was by our fault, but no damage has been caused because the person he wanted to vote has won the election. So, technically speaking, no damage has been caused to that person. Now, court there said that it is irrelevant whether damage has happened. Injury is enough to incur liability in tort, and that was the establishment of this maxim called injuria sine damno. Now, parallelly, in that same time, I also discussed about another maxim which is called damno sine injuria. Now, what damno sine injuria means? Again, for recap, I am just telling you. Damno sine injuria means damage has occurred but no injury to legal right. And I gave the example of these competing schools where one school teacher who was employed in a school now came out from that school by resigning his job, and then very close by to that school found a new school all by him. And because he was a very popular teacher, half of the students of the old school flocked to his school. Now, the old school filed a claim for damages caused due to loss of this admission of the students due to the opening of the new school by this teacher. The court did not deny the fact that yes, damage has happened, but the court asked the question, what is your legal right that you have been that has been injured in this case? And they could not show any legal right, because this is a part of fair competition. Anybody has a right to open any business as long as it is permitted by law. So, opening a school when you take due affiliation recognition is not something which is not permitted by law. So, you can open a school if you have the money, if you have the authority, you have the legal documents, then you can always file the school. So, there is no injury that has happened to the legal rights of the old school, but damage has happened. Now, when damage happens without injury, that is not law and that does not give rise to any tort. So, this is called damna sine injuria. So, when we talk about liabilities in torts, we have two extreme scenarios where in one end damage through intentionally caused actionable act has happened, yet those are not actionable in tort because no injury has happened. So, there is 100% damage, but there is no injury, so there is no torts. So, this is one side of extremity. On the other side, there is absolutely nothing in law that imposes that the defendant has committed a fault. Yet, in such scenarios, in certain extreme cases, the court still will rule in favor of liability, and this is called the strict liability. So, in one extreme you have the damage without injury, no torts. Another end you have no legal injury or no wrong committed by the defendant, yet for the damage caused the person is made to pay for the compensation for the damage. So, between these two extremes lie the third one, which is called the fault liability. So, basically when we say in torts we have these three types of liabilities. One is there is no liability, only damage. So, of course, that does not come within the concept of liability. So, there are two types of liabilities. One is fault based liability and the second is no fault based liability. Now, what is fault based liability? It is usually defined that fault based liability means where existence of fault in the form of intention, negligence or motive is essential to fashion liability on the wrongdoer. Now, if a person commits an accident and on the road without any negligence, then that person has not committed a tort, but under strict liability he may be found wrongdoer or he may have to compensate, but under the law of tort he is not found guilty because he has not committed any act which is intentional, which is negligent, which is motivated in order to constitute a rough tort. Similarly, when somebody has published against somebody and believing it to be truth, and he has verified and made all things, he may be given the privilege and defamation may not be levelled because he is a press and he has the duty of circulation of information for people's benefit at large. So therefore, whether if there is no fault, motivation or intention on his part to malign somebody, and when he has published something which may not be even true or may be defamatory, but he has made all the necessary followed steps to verify the information and he believes it to be truth, then in that case no defamation. So therefore, all these torts, in order to be committed, you need to show some element of fault on the part of the defendant where no justification can be also provided. Now, why the majority of the torts are based on fault liability? Because the public policy demands that defendant should not be made to pay for the loss arising from an event which he could not have avoided, and so the law provides liability on the principle of fault or wrongful act. So private defense is a justification. Now somebody attacks, you defend yourself, in that process you hit someone, it will not be a wrong of torts because you have a right to protect yourself. So wrong of tort of assault or battery can only be ascribed when that person was not justified. So there is a wrong. So he has committed this assault intentionally, negligently, or by having a motive to hit that person, and there was no justification for hitting that person. There was no justification on his part to to do that act. Then it is a wrongful or fault act, and that is what is fault based, and it is justified in the public policy that in that case punish. But when such scenarios does not exist, loss is arising not from an event which could be avoided by the defendant, then asking him to pay compensation for that is not correct. Second is the rule that damages allowable are proportioned to the damages or loss, and justifications either negative, the theory of fault, or used as mitigating factor in computing damages. That means, the rule of damages also try to figure out how much compensation to be paid based on the proportionality of the loss or damage suffered. And if there are justifications that why this damage has been caused by the plaintiff, then that can be the ground to negative his liability completely, or sometime he may have to still pay, but it can be a mitigating factor in computing the damage. For example, contributory negligence in cases of accidents. So if accident happens where the plaintiff has also some contribution into it, then plaintiff's contribution is decided, calculated or computed, and then it is become a mitigating factor in computation of the final damage. So therefore, maximum number of torts, you have to remember, maximum number of torts are fault based. So that is why you have to know what are the elements of proving that tort, and then you have to prove those elements in order to ensure that the person is incurring a liability in tort. And of course, he will try to always give some justification or defense for his act, which you have to nullify or negativate. But there are some tort, or one tort at least, where this showing of wrong intention or negligence on the part of the defendant is not necessary. What is necessary in this case is to show that what happened was under the control and from the property or the land of the defendant. That is enough. It is not necessary to show that it was because of the fault of the defendant, or because of some negligence on the part of the defendant, or because of some wrongful intention or motivational factors of the part of the defendant. The only thing that needs to be shown is that the property belonged to the defendant and the act happened from the property of the defendant, and which caused loss or damage to the property of the plaintiff. So this has to be shown. So this is called the strict liability, because this is a no fault liability, that is no fault is necessary to be shown. When earlier cases you have to show the fault, then it is a fault liability. But this is a no fault liability because no fault is necessary to be shown. Fault or no fault, if this chain of circumstances happen, the defendant will be held liable, right. So, that is why it is called no fault liability, and it is also called strict liability because there is no excuse or no allowance given from exonerating your liability under this. So, what is this strict liability? This strict liability was upheld in a very famous English case called Raylands versus Fletcher in 1868. And what Raylands versus Fletcher, the strict liability rule states is, when the occupier of a land who brings and keeps upon it anything likely to do damage if it escapes, is bound at his peril to prevent its escape, and is liable for the direct consequences of its escape, even if he has been guilty of any negligence. Now, yesterday we discussed the re polemis case. Okay. So, in the re polemis case, the charterer or the whom under the vessel was under the control had to pay compensation for the direct consequences of the negligence of their staff or their employees for the loss or damage caused to the vessel. Now, why you can say that it was a case for negligence or it was a case for strict liability? Because what was it carrying in the hold of the ship? It was carrying petrol or benzene. Now, what petrol or benzene is? Petrol or benzene. So, the word land needs not to be strictly only understand as land always. Land can include anything, building, any place under the control of the person who is alleged to have committed the wrong. So, any place, it can be a building, it can be a field, it can be a river, it can be a hold of a ship, it can be a cargo, whatever, it can be a warehouse. So, there is no limit to the word land. It means basically anything that is occupied or under the control of the person who is alleged to have committed the wrong. So, when the land was in occupier occupation, so in this case the hold was under the charterer's control, the ship was under the charterer's control, and he brings and keep upon it anything likely to damage if it escapes. Brings petrol or benzene which is inherently dangerous, and if it escapes, everybody knows it can cause very fatal consequences. So, therefore, it is now his liability. Now, it is complete liability without any excuse or justification to keep it within the peril and prevent it from escape. Keep it within the place where he has brought it and not escape. If it escapes for any reason, then he is liable to pay the consequences which are directly arising from that transaction or from that escape, and need not require to be an escape caused due to his negligence. So, he is directly liable, he is liable without any bounds or rules. Now, why this principle evolved and what was the facts of this case? So, let me use this page to pictorially represent. Now, say there are two lands A and B. Land A belongs to Ryland and land B belongs to Fletcher. Okay. Now, Rylands have his factory. In this land, and Fletcher is using this land for a coal mine. So, coal mine, factory, So, for coal mining operation, whatever and all the features and fundamental areas are required, he is having that here. Okay. Now, what Ryland does is that for the purpose of some stable water supply, he digs a big water tank. And fills it with water, and this water is brought from outside. Now, you may say, is water dangerous? Yes, at times water can be very dangerous, because water causes flood, water causes lot of damage if it is in huge volume escapes. So, therefore, water may be our life, water may be consisting of what we call 3/4 of our body. Even so, water can be also at times very dangerous. So, what Raylands do is that for the purpose of supply of his water, he digs a water tank here. So, he in his land, this belongs to his land only, this is all his land. So, in his land he builds this water tank and fills with water. Now, this whole operation is done by an independent contractor. So, it is not that the servants who or the people who constructs this water tank is his own employee. So, he has hired an independent contractor. And the employees of the independent contractor chose the place where it is to be dug and did the construction. Now, here in this end where the Raylands land and Fletcher's land met, there was a old shaft, and this shaft was built when this portion of the land was used for mining. So, after this portion of the land was used for mining and it was completed the activity, this portion, a shaft was built. But the independent contractor's employees did not adequately examine that whether this shaft is strong enough to now withstand the pressure of the water. This additional big lot of water that has come, whether it is enough. Now, they did not, and from the very beginning there were some places where water started leaking. So, leakage of water started because the shaft was not adequate, and the leakage slowly caused more damage, and finally one day a portion of the shaft broke down and huge water entered, and this entire portion of the coal mine which belongs to Fletcher was completely flooded and submerged in the water and caused huge loss to Fletcher. Now, Fletcher filed a case for seeking compensation. Problem was that under what ground or what theory of law Fletcher can establish his cause of action. Now, will this be a trespass? Now, it is very difficult. Will this be a negligence? Now, if negligence, Reynolds will not be involved because Reynolds has hired this independent contractor. So, if this has happened, this has happened due to the negligence of the independent contractor who is a third party, and therefore, the independent contractor. So, if trespass, whether it is trespass, whether it is negligence, whether it is nuisance, all these theories were tried, but somehow court was not satisfied. Of course, court was satisfied that a old theory of common law trespass could be used, trespass to property, but the court wanted to give it a new shape. So therefore, what the court did was, court adopted the rule of trespass but reformulated it as rule of strict liability. Or commonly we call Rayland versus Fletcher rule. Rayland versus Fletcher rule. Okay, sorry, not Rayland. Okay, and what the rule says? The rule says that when the occupier of a land who brings and keeps upon it anything likely to do damage, if it escapes, is bound at his peril to prevent its escape and is liable for the direct consequences of its escape, even if he has been guilty of, he is not guilty of any negligence. So in this case, Reynolds had no negligence because he used the third party. Reynolds had no intention, no motive, no fault. So therefore, it was held that it is not a fault liability, so it does not require any fault on the part of Reynolds. It was just enough that this land belongs to Reynolds. He brought this water, he digged this water tank which was earlier not existing. Then he brought water. Now digging water tank was not part of the natural use of his land because he was having a factory and there was no need for so much water to be stored, but still he for whatever purpose he thought he will bring such high volume of water, so he built that such big tank and then brought the water here, and once that water was brought, now it is his responsibility to prevent he is bound to keep it in his peril and prevent his escape, because it is a dangerous substance and it is not part of his natural requirements of the land use. So he has brought it in addition or for whatever purpose, not part of natural use of the land. Now in that circumstances, if these points are proved, then Rayland's or the defendant will be held liable. It is not necessary to show that defendant was negligent, the act was motivational or intentional. It is not required. There is no such requirement. Only damage has to be shown, that the leakage or escape has caused severe damage, which in this case was there. Severe damage. Okay. So the Rayland-Fletcher rule, if we break down into elements, we will see that Rayland-Fletcher rule is based on 5 important conditions to be satisfied. What is that? First condition, when the defendant brings, collects, keep in his land. When the defendant brings, collects, keep in his land. So something has to be brought or collected and kept or kept in his land, right? Which is inherently dangerous. Okay, something which is inherently dangerous, something which is not inherently dangerous, then bringing that, keeping that, collecting that does not have any problem. But when he brings, keeps, collects, something which is inherently dangerous and which is not part of his natural use of the land, which is not part of its natural use of the land, if it escapes, so escape has to happen, so it has to escape, and after escape what it does, it causes damage. So therefore, there are, what are the first 4 elements? First, it has to be brought, collected or kept in the land. What is that? That is an inherently dangerous substance. Then what? Then that collection, keeping or bringing that inherently dangerous substance is not part of the natural use of the land. So it is not part of the natural use of the land, and then that substance escapes and causes damage to the plaintiff. If all these 4 grounds are satisfied, then the plaintiff will have relief, except only these 4 particular exceptions should not be there. What are the exceptions? Wrongful act of the plaintiff, where the plaintiff is himself a wrongdoer, or it is an inevitable accident. It was outside the scope and control of the defendant. Inevitable accident, or an act of God, or lastly an act of a stranger or a third party. Now, in Reliance versus French's case, the third party angle was there, that it was a negligence on the part of the contractor. So, act of the stranger or third party, but subsequently that act of third party was modified also. So, therefore, again repeat, the 5 conditions that the Reliance rule has formulated is when the defendant brings, collects, keep in his land. So, very very important, when the defendant brings, collects, keep in his land something that is inherently dangerous, something that is inherently dangerous, not part of the natural use of the land, which is not part of the natural use of the land, that substance escapes and causes damage to the plaintiff, then he is liable. Only thing is that the escape cannot be justified by the defendant, that it was because of some wrong on the part of the plaintiff, that is the plaintiff is the wrongdoer, or an inevitable accident, or an act of a third party or stranger. Okay. So, 3 exceptions, because inevitable accident and act of God is basically said that they are the same body. Only thing is that where there is no unnatural phenomena involved, it is due to some human element, then it is falling within the control of inevitable accident, but where there is an unnatural event involved, then it goes to the domain of act of God. So, I hope you are now clear. So, there can be several examples. I will give you a small example to just test how well you have understood. Okay. So, there is a factory. The factory has kept phosphate. Basically, the factory is a rice mill, and it of course in its godown stores a lot of these grains. So, lot of grains are stored, and because grains are stored, rodents attack is very common, rats. So, rats are very common. So, in order to ensure that rats do not damage or cause destruction of the grains, the factory has brought and kept in the factory a huge quantity of phosphate, ammonium phosphate. A huge quantity of ammonium phosphate. Now, ammonium phosphate is usually not a problematic substance, right. So, and it works as a antidote to rat. It smells, make sure the rats do not come. So, a huge quantity of ammonium sulphate has been accumulated. In a huge quantity. Now, unfortunately, one day due to some mistake on the part of the employee or whatever, a fire broke out from short circuit, electric short circuit, and the entire factory was engulfed into the fire. Now, that was not the problem, because that was lost to the factory, so factory owner. But what happened is that in that fire, a lot of water was put to bring the fire under control, or to alight the fire. Now, with water being sprayed on warm ammonium phosphate which was already stored there, which has become warm due to fire. So, the warm ammonium phosphate coming in contact with H2O converted into a gas which was highly poisonous, called phosphine. Highly poisonous or intoxicating toxic gas called phosphine, and this phosphine escaped and it spread over the entire population of that area, and the local people, nearly half of them who inhaled that gas died. A large number of people were in hospital suffering very serious injury. Almost a lot of children and young born babies died because of this. So, this has happened. Now, can you say that whether the factory can be held liable in this case under the strict liability rule? The answer is yes. How do you do that? The answer is that the factory is a rice mill. Now, bringing ammonium phosphate was not part of its natural use, but still can be justified in that huge quantity. Now, that ammonium phosphate was something which was not inherently dangerous, but it can be dangerous when under certain conditions. And when that factory caught fire and water was put, that ammonium phosphate gave rise to this phosphine gas, and that gas then escaped, and that caused loss and damage. So, therefore, it comes within the domain of what we call a strict liability, but rather it is because in Indian case it can be justified under something which we will study in the next class, which is absolute liability. Which is the Indian rule. Okay? But this can be justified also under the strict liability rule. Only thing is that there is one problem, and that problem did not happen because of application of Rayland-Fletcher, but that problem has arisen because of the application of the Rayland-Fletcher in a subsequent case which is called the Cambridge water. Now, what is the Cambridge water case? The facts of the Cambridge water case is that this case concerns with the question whether Eastern Counties Leather PCL, ECL, a company Eastern Counties Leather, is liable to Cambridge Water Company, which is a water supplier of potable and drinking water. So, is this ECL liable to CWC, that is the Cambridge Water Company, in damages in respect of damage suffered by the region of contamination of water available for abstraction at the CCS borewell at Stotson Mill near Cambridge. So, what happened? Let me again try to provide you through a pictorial representation. Okay. So, this was this ECL company, and they had a leather factory. Now, in the leather manufacturing process, there are a lot of chemicals that are necessary for tanning, for cleaning, for drying. So, various types of chemical components are required. Now, one of the chemical components that is required for the purpose of tanning work, which was present and in huge amount in the Stotson workshop of ECL. Stotson is a place where Sawston, not Stotson. Sawston is the name of the place where this whole incident happened. So, ECL's factory in Sawston had a huge deposition, huge collection of this PCE. It's a chemical component PCE, which meant percolethine, a particular component which is used for the purpose of tanning work. Now, PCE was stored in a godown, and it was made sure that adequate care was taken that the PCE cannot escape in the environment otherwise. Okay, all the normal whatever foreseeable reasonable care to be taken, they were all taken. But what happened was that the PC, when it came in contact with the ground surface, so the PC say was stored here in sacks. It's a solid sort of semi-solid, so it was kept in sacks. When the sacks came with contact with slightly moist water, moist soil, so moist soil, it started, you know, leaking and contaminating the underground soil. So it started contaminating the underground soil, and over very long period of time, almost 17 years, this phenomena continued, and almost an area of 1.25 kilometers radius of the ECL factory location, the entire underground water which is the main, resource for the Cambridge water, was contaminated with PCE, and which now made the water not anymore usable, appropriate for human use, unless it is treated, and that too the treatment was to be very difficult, because how do you find how much quantity is there, and there are WHO's different protocols. So the whole contextually it was a case of groundwater pollution, and therefore Cambridge Water Company filed a case for compensating for their damages under negligence, nuisance and Rayland rule, that is strict liability. Now, the trial court ruled out negligence and nuisance in this case. They said that negligence, nuisance cannot be proved in this case, but it upheld the Rayland's rule. It upheld the Rayland's rule. It said yes, as per the Rayland's rule, it is there is a liability on the part of the ECL, because you see ECL had brought this PC. Now, it may happen that PC is not an inherently dangerous substance. Also, bringing PC is not something an unnatural use of their land, because it was a factory for leather tanning. PC is necessary component for leather tanning, and therefore it may be required every day. So therefore storing in a huge quantity is not bad. It took all adequate care, but still it leaked, and it's got contaminated into the surface, and that percolated down and contaminated the entire groundwater of a radius area of 1.25 kilometer surrounding the Swartson factory. So the court here held that it may not be inherently dangerous at the beginning, but it will be dangerous, and here there is no need for showing fault or etc. It's a no fault rule. So by using a stricter interpretation, the trial court upheld the Rayland's case on the Rayland's rule, the liability of the ECL. So ECL was held liable. But then the matter went to the appeal. Now ECL was held liable. Now in appeal, the House of Lords reversed the decision. What House of Lords held? So, the decision or the issue to be decided before the House of Lords was the decision holding ECL to be strictly liable in damages of CWC with respect to contamination of the percolating water available for extraction of CWC from its borewell at Swatson Mill was recognized by the House of Lords or was reconsidered by the House of Lords. What did the House of Lords say? The House of Lords, allowing the appeal and reversing the decision of the Court of Appeals, held that foreseeability of damage is a prerequisite of the recovery of damage under the rule. So, what House of Lords held that the general tenor of this statement of the principle is therefore that knowledge or at least foreseeability of the risk is a prerequisite of the recovery of damages under the principle, but that the principle is one of the strict liability in the sense that the defendant may be held liable notwithstanding that he was exercising all due care to prevent the escape from occurring. So, it is not necessary that he has taken all the precautionary care. The question is that what and how the event happened, the escape happened, whether it could have been foreseeable. So, whether this act can be foreseeable in this scenario. Okay. Now, what Cambridge Water went in their favor, sorry, what went in ECL's favor is that it is not that ECL has taken all the reasonable care to all that, reasonable care for all the foreseeable damages. But this PCE soaking with moist water, getting mixed into the soil, then it is getting into the groundwater, percolating through the groundwater, polluting the groundwater in period of 17 years over a radius of 1.25 kilometer is far fetched to be foreseen. And that is where they made it a day. So, therefore, if we go and look at the elements which we discussed, now along with these 5 elements which were actually part of the original Raylands versus Fetcher, a 6th element is included by the Cambridge Water, which is foreseeability. So, that is why I said this scenario is absolutely falling within this scope. But the moment foreseeability comes, because phosphine gas will be evolved and that will escape and cause, this is something which may be a question about the foreseeability when we look at this example, right. So, unless you say that no exception, which is usually done in the Indian cases. Now, foreseeability is something that was added into the Raylands-Fetcher rule by the Cambridge Water case. But the future that Cambridge Water left was that liability under the rule in Raylands-Fetcher appears to be appropriate to take the view that foreseeability of damage of the relevant type should be regarded as a prerequisite of the liability in damage under the rule. Such a conclusion can, as I have already stated, be derived from Blackburn's, the person who wrote this rule in the Raylands versus Fetcher case, Blackburn's J's original statement of the law, and I can see no good reason why this prerequisite should not be recognized under the rule, as it has been in the case of private nuisance in particular. So, court says that in private nuisance in particular, foreseeability is an important factor. So, when foreseeability is an important factor for damage caused, then therefore, it is necessary that in case of strict liability also, the foreseeability factor should also be a prerequisite. So, based on this foreseeability prerequisite, now we have 6 things to show. And because of this, so many elements with diverse factors, partially the Reynolds rule has become a little difficult to implement. And this has been highlighted in this case of Brunei Port Authority versus General Papa Jones by an Australian court. Now, again, let me just provide you the facts of this case. So, this Brunei Port Authority had a warehouse. And in that warehouse, General Jones had a huge cold storage. So, this warehouse belonged to BPA, Brunei Port Authority. And inside this warehouse, one portion was occupied where a cold storage was there by General Jones for storing vegetables. It was in vegetables business. Now, BPA decided that apart from General Jones, there are many other companies who are requesting for extension of this cold storage facility. So, cold storage. So, therefore, they required to construct more cold storage. So, they decided that at the top and at this side they will develop a number of more cold storages. Now, for this purpose, what they did was that they hired an independent contractor and gave the responsibility to construct. Now, the independent contractor started its work. Now, for the purpose of insulation required for the manufacturing of the inner walls of the cold storage, what it did was that it brought some substance which is called, 1 minute, I will just show you. So, it brought a substance which is highly inflammable. And stored it at the top of the house. So, this was that highly inflammable substance, okay, which was stored here. Highly inflammable substance which was stored here. And they did not took adequate caution, or they did not notified that this is something which is highly inflammable substance, right. And the welding work. So, this insulation work was supposed to be done by so basically what BPA did was BPA contracted to say A for the whole work. Now, A subcontracted the insulation work to B, the welding work to C, and the electrical work to D. So, A was the main contractor and then A subcontracted to B, C, D for particular work. Now, B, who was the insulating, whose responsibility was insulation, now he had brought these substances and has kept it, because this material was only for his use, but he has not given any caution. Similarly, BPA also knew that these substances are there, it also did not issue any caution to either of C, D or even A. Now, when C was working here for welding work, some hot molten metals, when C's workers were working here, some hot molten metals fell and fire broke, because it is highly combustible. The whole building, including the cold storage of General Jones, was completely damaged. Now, General Jones filed a case for compensation. Now, obviously again three theory: negligence, nuisance and strict liability. Now, with the strict liability rule, here the court had a problem. The court said, can we say welding in a warehouse kind of setup a non-natural use? Of course, this is a dangerous substance, the rest of the rules, even foreseeability can also be added. But can welding be said as a non-natural use or a non-natural work in a warehouse scenario? Of course not. So, the problem was that with so many components, the application of the reliance feature rule was becoming so difficult. And the court said that now, because the negligence rule with the duty of care principle has become so elongated and so wide in its scope, that now these all aspects can come under negligence. So the court ruled out the reliance pressure and said that it is very limited to be applied because of or even if I wish, because of so many elements it is difficult to apply. So therefore negligence was used to find the fault on the part of the Brunei Port Authority to compensate General Jones. So court said, and I quote, "The rule of reliance pressure will all its difficulties, uncertainties, qualifications, exceptions should now be seen as absorbed by the rule of ordinary negligence. Under those principles, a person who takes advantages of his own or her control of premise to introduce a dangerous substance, to carry on dangerous activity, allow another to do one of those things, owes a duty of reasonable care to avoid reasonable foreseeable risk of injury or damage to person or property of another." So basically what we are seeing that the fault liability is kind of over encompassingly taking over the no fault or strict liability. So I am at the end of this want to sum up that liability finding in tort is very important. As you have seen through the cases that we discussed, that usually several theories of liabilities are pleaded in order to see that if one miss then another can be picked up. But it is important to make these choices, and this is a very important aspect of a lawyer. Thank you very much, and I hope to see you in the next class. Thank you.